The question of when does property in goods pass from the seller to the buyer is very important because look, things like your phone, your car, your watch, your whatever it is, okay? These things are yours even if I'm using them. What makes them yours is not possession, but ownership. The question therefore is, at what precise point will property in goods stop being those of the seller and become the buyer's? Well, in this video, you find out. Now, there are a number of reasons why it's important for you to be very particular about when property in goods passes from the seller to the buyer. Such reasons include, it is the purpose of the contract of sale of goods that property passes to the buyer. Number 2, it determines when risks passes from the buyer and hence the party liable in the event of loss or destruction of goods. I mean, think about it. If you buy something from, say, a supermarket and they promise to deliver, right? You've already bought that thing and they tell you we'll drop it at your house. Well, if that supermarket goes up in flame, is insurance going to pay for the refrigerator that you bought? Is it your property or is it the supermarket's property? Think about it. Number 3, it determines what remedies are available to the seller. For instance, the seller cannot sue for the price before property in goods passes to the buyer. Of course, different contracts have different rules regarding the transfer of property in goods. But some of those rules will include the following. Now, before we talk about them, you need to understand two things. In our previous video, one of the previous videos, we talked about the types of goods and we said goods can be ascertained or goods can be unascertained. So in this case, we're talking about those two. You're talking about when will property pass from the seller to the buyer if the goods have been ascertained, and when will property in goods pass from the seller to the buyer if those goods aren't ascertained. So let's start with the ascertained goods. Specific goods or ascertained goods are goods that have been identified and agreed upon at the time the contract is made. When it comes to transfer of ownership in this kind of goods, the ownership will transfer exactly at the time when the parties intended it to transfer, which means intention becomes the key thing here. So the intention of the parties will be determined through the following: the terms of the contract, the conduct of the parties, and the circumstances of the case. Unless contrary intentions arise, the following are going to be rules regarding transfer of ownership of ascertained goods. Number 1, where there is an unconditional contract for the sale of specific goods in a deliverable state, the property passes to the buyer when the contract is made. Deliverable state means that a state in which the buyer will be bound to take delivery. Okay, to make this one more clear, let's look at a case. Let's talk about Philip Head and Sons v. Showfronts, 1970. So in this case, the defendants bought a carpet from the plaintiff. When the carpet was delivered to the showroom where it was to be laid, it was found that it could not fit properly and had to be sent away for stitching. It was returned the next day wrapped in heavy bales. It was stolen before it could be laid and the defendants refused to pay for it. Now in this case, it was held that the property in the carpet had not passed to them. Okay, the property had not passed to the buyer, since at the time it was stolen, it was not in a deliverable state. So again, remember, deliverable state simply means a state in which the buyer will accept the goods. So as far as the carpet is concerned, it being wrapped and all that, that wasn't exactly the state in which the buyer expected the goods. Now the second one is, if the contract of sale of goods is for specific goods not in deliverable state, meaning that the seller has to do something to those goods to put them in deliverable state, the property will not pass until that thing is done. Number 3, where there is a contract for sale of specific goods already in deliverable state, but the seller is bound to measure, weigh, test, basically do something to ascertain the price, the property does not pass until that thing is done and the buyer has notice of it. Those rules are some of the rules that will govern transfer of ascertained goods. But of course, as I said, we have ascertained goods and we have unascertained goods. When it comes to unascertained goods, we're talking about goods that are defined by description only and not goods identified and agreed upon when the contract is made. For instance, 600 bags of maize is a description if you are not looking at the maize. Now, property in goods, when you're talking about ascertained goods, basically the ownership of these goods will only be transferred once those goods have been ascertained. So, Up to there, I hope you're in a position to explain how we transfer goods from the seller to the buyer. And also, if those goods are ascertained, what are the rules? If they are unascertained, what are the rules? I'm also assuming that you're in a position to explain why it's important to know at what point, okay, the goods, the ownership rather, is going to pass from the seller to the buyer. So if you have any question, as always, do let me know. From either, you can inbox, you can email, you can hit any of my social media accounts. You can even ask the question in YouTube. I'm Moses from Zerite Network, and I'll see you in the next lesson.